No one in this community should have to live in fear of someone like James Barnes Morris.
Strong words from the father of a murder victim whose body was found in a pond in Wisconsin. And quote, "The weeds made it hard." The chilling words the suspect allegedly said to a friend about hiding the girl's body. We're on the case, presented by Law and Crime. I'm Chris Stewart. We're following the story of a young girl who was murdered allegedly by a suspect who was given second chance after second chance. But now he may have spent his last days outside of custody. First, I want to start with the victim in this story. Her name is Brooke Stratton. She was 24 years old, and according to her obituary, she touched the hearts of everyone who knew her with a generous spirit. And she loved to camp. She enjoyed spending time outdoors. She was last seen on September 30th of last year in Madison, Wisconsin. Police say she was walking with her boyfriend, James Barnes Morris. I'll get to him. He's accused of in this story and the laundry list of other cases that make up his criminal record in just a moment. Initially, authorities put out an alert for Stratton as a missing person, but on October 3rd, a body was pulled from a pond on the campus of the University of Wisconsin. It was identified a few days later as the girl whose family says she'll be remembered for her kindness, love of nature, and devotion to helping others. The search for the person police believed was responsible did not take long. Barnes Morris was the last person to be seen with Stratton and was arrested the same day that her body was pulled from that pond. According to a police search warrant first obtained by WKOW in Madison, Barnes Morris was found hiding at a friend's house with a suitcase that had Stratton's cell phone and credit cards. On top of that, police say Barnes Morris met with a friend hours after Stratton went missing, and he allegedly was wet and had scratches on his leg. And he allegedly had a few drinks later that night and had a lot more to say. A friend told police that Barnes Morris told them, quote, "I had to get rid of her, and he needed more bricks and rope, and the weeds made it hard." This is all according to that search warrant that WKOW got from police. Barnes Morris then told police that he said getting rid of Stratton meant as a girlfriend. Also, before asking for a lawyer, he allegedly laughed at the comments about needing bricks and rope. In October, police recommended that he face first-degree murder charges, but the district attorney in Dane County, Wisconsin, didn't file charges until March 2025. And part of the reason for that was they were reportedly waiting on Stratton's autopsy. You'll hear more about what Stratton's family said about Barnes Morris in just a moment, specifically about his criminal record. Barnes Morris is now being charged with Stratton's murder, but he's been in custody since October 3rd when his girlfriend's body was found before she was allegedly killed. A person who owned the home where Barnes Morris was found hiding said that a couple days earlier they had a party and the couple came over. And according to WKOW, Stratton and Barnes Morris got into a heated argument, and it was so heated that Stratton reportedly stayed at a friend's house that night and even told that friend that she feared that Barnes Morris was going to kill her. This relationship is sadly too common in cases of domestic abuse, and according to a criminal complaint, Stratton and Barnes Morris started dating in the fall of 2023. At one point, they lived together. He allegedly beat her and nearly killed her several times. They were estranged at the time of Stratton's death. Now Barnes Morris is facing first-degree murder charges and a domestic abuse enhancer, which adds to the severity of the charges that he is facing. The 25-year-old made his first court appearance on that murder charge last week. When determining whether he should receive bail, Stratton's family was allowed to virtually address the court. Here is what her dad said.
Your Honor, I am Kevin Stratton, and I stand before you today as a grieving father, asking you to consider the full scope of the danger James Barnes Morris represents to the community as you set his bail. My daughter, Brooke, was tragically taken from us by James Barnes Morris. James is not someone who made a single mistake. He is a violent criminal with a long history of terrorizing others. Just 3 days after his 18th birthday in 2017, he began his criminal career. Since then, he has accumulated 17 criminal cases spanning multiple counties in Wisconsin. Among his offenses are violent crimes, including armed robbery, false imprisonment, assault, in which he held a shotgun to a teenager's head, and forcibly dragged a young woman into a car against her will. His violent behavior shows he has no regard for the law, for human life, or for the second chances given to him. James was given probation, yet he violated those terms in June 2024. To my understanding, he was then given another chance, an alternative to probation requiring detention at a halfway house. Instead, he claimed he had appendicitis during the last weekend of September and absconded to party for the weekend. On September 30th, 2024, he killed my daughter. While I understand that James is currently serving time for his previous armed robbery conviction and will not be released for another few years, I ask that you will still consider his violent history and his total disregard for the law. His history of escalating violence speaks volumes. He took my daughter's life. And it was not an isolated event. This is part of a disturbing pattern of violence and disregard for the law. My family's desire is that, given the severity of his actions and his complete lack of regard for the law, bail be denied entirely in this case. We believe that he poses an ongoing threat to society and should not be granted any opportunity to further endanger the community. If bail is considered, I respectfully ask that it be set to the highest possible level, keeping in mind the danger he poses. No one in this community should have to live in fear of someone like James Barnes Morris.
Barnes Morris has an extensive criminal record. If you search his name online, you can find multiple stories with multiple mugshots, including these from an armed robbery in 2019. He was charged with several felonies in that case, like for armed robbery, false imprisonment, and strangulation and suffocation for holding up a juvenile at gunpoint. This was according to the northern Wisconsin news site DrydenWire.com. The site says that the court imposed a sentence of 5 years initial confinement, 5 years of extended supervision, 5 years of probation, and 6 months of conditional jail time subject to work release, mental health release on an amended charge of robbery with threat of force. Now, that is a lot to say, but clearly he was free enough to start dating Stratton in 2023 and then allegedly kill her in 2024. The state requested that Barnes Morris be held on $1 million bond. Here's what his attorney had to say.
Your Honor, I'll note that Mr. Barnes Morris was revoked from supervision. He's serving a 5-year initial confinement sentence. I don't think that bail is of any consequence at this point. It would be surprising if this case was still pending in 4.5 years. But we will stipulate to the cash bond that the state has requested, given that information.
All right, thank you.
So the defense didn't oppose what the state wanted because Barnes Morris is already in jail on a probation violation. Here's what the judge had to say.
Maybe I'll just make a statement first about the nature of bail, and particularly the nature of bail in first-degree intentional homicide cases. There is a legal provision that allows for the state to request that a person be held without bail, but that I just not even consider the issue of setting either a cash bail or some other form of bail. That has not been invoked in this case. The district attorney has made the decision not to pursue it. And to be fair, I don't know whether Mr. Barnes Morris would qualify. There's some specific requirements, and they're not to be redundant, but they're very specific requirements. They don't apply in every homicide case. There's also, of course, the practical side of this, and that invoking that process involves a fair amount of additional process. It involves a fair amount of additional showing, and likely not to a particularly purposeful end when the person is already serving a sentence of a number of years and really isn't eligible for release under any circumstance anyway, at least during that time period, of course. So I make that observation because I think I must. It's a fair observation to make about the nature of the offense. And I want to be responsive to Mr. Stratton's point, and I think it's a legitimate one about why we're having a conversation about bail in a case where somebody's charged with the most serious offense that somebody can be charged with in the state of Wisconsin. But that means that I'm obligated to set some sort of bail in the case. Then I'm supposed to set it at an amount that's designed to protect members of the public. It's designed to assure the appearance of the defendant for court proceedings, to prevent witness intimidation, and there's a list of other factors that are also present. Those factors support a substantial cash bail. There's no question about that. The joint recommendation is a very substantial cash bail. It's an amount of money that in my about 30 years or so around the system here, I've never seen anyone post. And it would be a situation where if he posted that, he'd also have to be through serving his sentence, or some sort of significant change would have to occur in his underlying sentence before he could be released. Under those circumstances, I can understand why it's seen as unacceptably low if one was in the position of Mr. Stratton and perhaps other family members, but I think it is a reasonable and appropriate recommendation, and I'll adopt it. So I am going to set cash bail at $1 million. I'll order that he's not to have any contact with any immediate family member of Brooke Stratton.
Joining me now to talk more about this case is criminal defense attorney, former prosecutor Jeremy Eldridge. Thanks for joining us here on Law and Crime. You have this case, and unfortunately, there's too many domestic violence cases like this, and now you have a defendant with a pretty lengthy criminal record as well. What stands out to you?
What stands out to me is the fact that the victim's family was able to document to the court a serious and lengthy pattern of abuse while this individual was still on probation, and the fact that there wasn't a probation violation lodged earlier to potentially have prevented this scenario from occurring.
And you look at this bond hearing, I thought it was interesting, and we cover cases, and as you know, every single state is different, but to have the family be able to come in over Zoom or Skype or whatever it was and make a statement to the court, how common do you see that?
So in most states, there's what's called a victim's rights statute or something similar, in which victims of crime or their families have the absolute opportunity to address the court at critical stages during the proceedings. And one of those critical stages is often the bail review or bond review, or in federal court, we call them detention hearings. And the purpose of the family being able to participate is so that they can tell the court, are they scared? Have they been threatened? Or if the victim is still alive, which they're not in this situation, do I believe that I will be able to continue on my life without constant fear if this individual is not detained? So the family being able to weigh in here is incredibly common. What is strikingly dissimilar from my experience as a former prosecutor and current defense attorney was the length to which the family was allowed to talk to the court about the defendant's criminal history, about his participation in the criminal justice system, and then their opinions about his prior cases. That was incredibly uncommon.
Yeah, and as a defense attorney, do you have an opportunity to push back? You didn't hear much of a pushback from his defense attorney in this hearing, but what opportunity is there for the defense to try and make, and I know he has a long criminal record, so it's difficult perhaps to make that argument allegedly, but what opportunity does a defense attorney have? What should a defense attorney do in that situation to try and balance things out?
And that's a great question. Looking at this pragmatically, you have to understand the practical approach that the defense attorney took here, which is the defendant here is already serving a sentence. So because he's serving a 5-year sentence relating to a violation of probation, there was no real opportunity to get this young man out of jail. So the defense attorney not jumping up and down and trying to make a colorful argument is not wildly unsurprising. But in a situation where there is an ability to get your client out, or at least the opportunity, then you would have been objecting to a lot of the testimony provided by the parents. You also would have objected to some of the comments, frankly, that the court made. It was a little bit surprising to hear the court sympathizing so much so with the victim's family. And it's not because I disagree with the idea of sympathy in the courtroom, but frankly, the judge was a little out of line conveying his sympathies. The judge is supposed to be an unbiased party, not swayed by emotion, and not discussing his own personal opinions with the victim's family, the state, or the defense. So the bottom line is the defense attorney just didn't object to any of it because it didn't matter in the long run. But in a different situation on a different day, that was inappropriate behavior.
Are those type of statements, and I don't know if this judge will be up to be the judge if this ends up going to trial, but is this something where if you're the defense attorney, you can take the statements that were made in this initial bond hearing and then present it forward if this is a judge you don't want to have on the bench for a trial?
100%. Not only could it potentially show that there's a conflict, although a different judge would likely have to decide whether those comments were actually a problem moving forward. I think the second issue would be, let's say that this individual serves his sentence and then he potentially is eligible for a bond, or they file an appeal of his bond, or what's called a habeas corpus petition, which is saying that the district court judge abused their discretion and didn't follow the rules governing release. These are the types of comments that could be brought up later to say, you made decisions that were not based in fact or law. You made decisions regarding your emotions. They were inappropriate, and those were an abuse of discretion. So it really is just something that was unnecessary by the court, didn't need to be done. There are obviously, even if you feel that way as a judge, you shouldn't really make those comments publicly.
When it comes to this case and the evidence that it appears the prosecution has at this point, the defendant came home to a friend's house after this apparently happened and was wet and covered in scratches, then made statements later that night after he had been drinking about getting rid of the victim, about needing rope and bricks, saying that the weeds were difficult to hide the body. When you look at what the prosecution has in this case, how strong of a case does it appear they have?
Right now, the case looks incredibly strong, but most cases, when they're initially charged, all the information that the public is receiving and that's put into the ether is the information that is most favorable to the state. So if they have cooperating witnesses, in the state's theory of the case, which is usually in what's called the statement of probable cause, which is the document that we, the public, get access to at this stage, the state's not going to put in any evidence that cuts against their theory or affects another witness's credibility. So could we find out later that the person that he supposedly confessed to actually helped to bury the body or was involved in the potential murder? Yes, that stuff happens all the time. So usually what I tell people is you can't take this initial police report or the initial set of facts as gospel. You have to take it with a grain of salt. But at first blush, it certainly seems like a very strong case.
And he's charged not just with first-degree murder, but there is, and I know each state is different, but we see it in different states. The domestic violence enhancer is what Wisconsin has. How effective are those charges on top of what is already an incredibly serious charge of first-degree murder?
It's incredibly important. Oftentimes, later on in the litigation, as you get close to a trial date, when a plea offer is conveyed by the state's attorney to the defense attorney and then obviously consequently referred to the client, in those discussions, that's where you're starting to have conversations about the effect of the enhancements, because it's very good leverage for the prosecutor to say, if you take a deal X, then we won't invoke the enhancement against you. And so what it does is it really forces the defendant to make two decisions. Not only one, that if I go to trial and lose, what is the maximum penalty for the crime charged? But then also, if I go to trial and lose, will the sentencing enhancement put me in a place that makes me even more uncomfortable? Can I test the waters losing at 30 or 40 years? But if I have 20 on top of that, am I willing to test those same waters? So it's a series of conversation that takes place later that oftentimes induces defendants to plead guilty.
And this defendant, we talked about it, has a lengthy criminal history. According to the family of Brooke Stratton, in their statement, he has been involved in more than a dozen cases since he turned 18 years old, which was back in 2017. There was this armed robbery case that played out. How could all of that factor into this trial? Will the jury ever hear about that criminal history? Or is it something where they have to hear it within the vacuum of the facts of this case?
That is such a great and complicated question. So let's take that in a couple parts.
Yeah.
The first thing is that whenever we're talking about somebody's criminal history, those are really messy waters to swim in, because it depends on the outcome of those individual cases. So if those cases resulted in guilty verdicts and those cases were not expunged from his criminal record, then at sentencing, those cases are not to say admissible, but they're certainly relevant to determining what an appropriate sentence would be. Things like what are called sentencing guidelines, mathematical calculations, given somebody's criminal history and the seriousness of those offenses, usually provide a sentencing range for the judge to look at to decide what an appropriate sentence is. And that's the point of having a criminal history available to the court. So that's one place in which it's important. When we're talking about going to trial, there are a couple of times during a trial where the jury could have the unique opportunity to learn about the defendant's past. Should the defendant choose to testify, for instance, there can be what's called impeachment by conviction, meaning if you've ever been found guilty of crimes of dishonesty or major felonies, kidnapping, rape, robbery, like in this circumstance, if he chooses to testify, that conviction could be brought to the jury's attention. Not to say that because he committed a robbery that he's guilty in this case, but more importantly to say because he committed robbery, which is not only a violent crime, but also a crime of dishonesty, that could in fact affect his credibility. And credibility is a threshold matter for the jury to consider in deciding whether to believe somebody. So that is a really important thing. And that also happens for witnesses. If there are witnesses with criminal histories, that same issue gets fleshed out before the judge first and then before the jury.
Because I always think, I mean, for myself, if I was a juror and then you find out after the fact that, oh, this guy's been involved in a dozen cases, he has a violent past, it definitely makes you look at a defendant in a different way. And I know there's a debate about whether or not that would be fair to that person. But let's talk about this criminal history a little bit, because I think in too many cases across this country, you see someone who has been arrested 12, 15 times, more than a dozen times since he was 17 years old, or excuse me, 2017 when he was 18 years old. In this case, according to the family, often in your experience, because you've been you are a defense attorney, you were a former prosecutor. How does it happen that someone is arrested so many times and seemingly gets so many chances to be out and be free and be within society?
The number one reason that this young man was given so many chances and released is his age. Judges oftentimes, when young people come before them, want to give youthful offenders an opportunity to not be confined. There is finite literature that exists regarding the impact of incarceration on young people. It's simply an issue that is not up for debate. The problem with that issue is that in situations like this, where judges are being viewed as giving a youthful offender too many chances, and then something catastrophic like murder happens, then the judges giving that youthful offender the benefit of the doubt is taken into question, and we end up in situations exactly like this.
For you as a criminal defense attorney, and if you were, I'm not asking about specific cases you've done, but times you've gone in front of a judge, do you know you have a pretty good shot at getting a favorable ruling when you have someone who is young, like apparently in this case, where you know that this person eventually keeps getting second chance after second chance?
Look, what rules the day at any bond or detention hearing is always going to be the nature of the charge. So we have like a curved grading system, right? We know the more serious the charge, the more difficult it's going to be to convince a judge to let your client out. But the ways to often mitigate that curve are bringing things up like an individual's age. So when I go in with a youthful offender, if there's not serious bodily injury or death, but the charge is serious, for instance, the pointing of a firearm, or we see a lot of high school robberies with airsoft guns or BB guns. Sometimes you can convince a judge that this individual, because of the world that we live in with social media and the movies these kids are watching and the music, and if they've never been in trouble before and the parents can come to court, you might have a decent shot at getting them home and then having their liberty restricted. Home detention, only going to school, or maybe even being homeschooled. But you really have to put a plan together with a third-party custodian like a parent to convince a judge, even in these situations, that they're not going to be a problem. And I'll tell you, even here in Howard County, Maryland, where I live and where I work, we just had a young man who was on home detention, who was released for a very serious crime by a judge, and then shortly after that, within weeks, actually is accused of murdering somebody at Columbia Mall. So that exact question is being examined locally as we speak.
I think too, in these domestic violence cases, because they do happen too often. I mean, there's statistics anyone can look up that it just seems to happen over and over and over again, for as sad as they are. And I just think of, for you having been a prosecutor, how do we prevent these cases from happening? Because even though you do have these enhancers that come to the charges, I mean, that's very much after the fact. I mean, if he ends up being convicted, the enhancer adds on to his sentence, it doesn't bring Brooke Stratton back. What have you seen as effective deterrence in these cases of domestic violence?
Well, before we even get to deterrence, we have to ask the question, what would work better on the front end? And I'll tell you is, I like the way that the federal government handles detention hearings. The first thing is the government seeking detention or not? So if they're not seeking detention, oftentimes the judge will put them on pretrial release. The second thing is, and this is because the federal government has more money, there's more work put into the front end of these cases. You have somebody from pretrial that meets with the defendant, somebody that may meet with family members, screens them for GPS monitoring, screens them for detention, and you have that hearing within 5 days. And the benefit of that is everyone at the table has a lot more information and a lot more of it is confirmed. So the court can make a more informed decision, although it may take a little bit longer. The problem is most of the states, unlike the federal government, have a very quick arrest to bond review, and this is by law, that you have to be presented in front of a commissioner to determine release in 24 hours, or being presented to a judge for a bail review within a certain amount of time. So the obvious solution here would be to craft a system, potentially, where a little bit more attention is given to the information we're collecting on the front end to help make better decisions. You'd be surprised how much that would affect it. On the back end, as far as deterrence, the courts and the system need to believe that deterrence works. We need to believe that if you hit somebody over the head with a hammer, or as my friend who is a prosecutor and an elected official locally would say, launch violent offenders into outer space or into orbit. The problem is deterrence isn't shown to actually have that impact, but it definitely makes the public feel safer when they read in the paper that, oh, this person committed a violent crime and we don't ever have to worry about them again. So finding that balance where the public sentiment or the public's need for justice is satiated vis-a-vis a punishment maybe looks like deterrence, but the impact is nay.
Also, one question I had related to the bond was he gets $1 million bond, and then there's this discussion where it seems like all parties, the judge, prosecution, defense, are like, well, he's not going to be able to make $1 million, so we'll just put it at $1 million. Like, why does he get bond anyway? If it's even seems like everybody's agreeing that he wouldn't be able to make it and he should be kept behind bars anyway.
Yeah, the cash bond systems that we have in a lot of states across the University of America it's a really antiquated system. A lot of states have moved away of the actual use of cash bond, but there are two issues here. Number one is a lot of the states left it in as just another tool in the toolbox. So in certain situations, if they think a cash bond is appropriate, they can use it. Even though other things like an unsecured bond, meaning if you don't show up to court, you actually owe the court money, home detention, GPS monitoring, may be more common usages by the court. But in some states like Wisconsin, you're required to actually set a cash bond. And the reason you're required is under the law, if you don't set a cash bond, or the state does not prove by clear and convincing evidence that you've committed a felony in your past, which here they easily could have, then the no bond finding isn't actually available to the court. And you hear during the initial appearance, the judge in this case discussing the fact that because the state did not seek the no bond status, that the judge didn't need to make that ruling. Probably once again, because the defendant was already serving a lengthy term of imprisonment while this matter is pending. So the state didn't feel the need to overplay its hand.
Very fascinating. Always fascinating to see the different states, when we cover different stories. Some states it's just no bond. And then in this case, we've had a few Wisconsin cases where it seems like there's just this debate about a number that they don't believe that the defendant would even be able to meet anyway. So it's fascinating to look at. Jeremy Eldridge, criminal defense attorney, former prosecutor. Thank you for joining us on Law&Crime. We appreciate it.
Thanks for having me.
Brooke Stratton was laid to rest in October 2024, less than 2 weeks after her body was pulled from that pond. Her family requested that people make donations in her memory to the National Alliance on Mental Illness and Domestic Abuse Intervention Services in her honor. And as you can see, many people did that in hopes of preventing future cases of domestic violence. For On the Case, presented by Law&Crime, I'm Chris Stewart. We'll see you next time.